The Honorable, the Supreme Court.
Good morning, everybody. Thanks so much. Please be seated. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Danielle Lacroix versus Peter Rysz, case number 23AP350. Representing the appellant, Peter Rysz, is attorney Barney Brannon. President counsel table with Barney Brannon is attorney Joseph Tremblay. Representing the appellee, Danielle Lacroix, is attorney Sharon Annis.
Okay, thank you, counsel. Come on up, please.
Thank you, Your Honor.
If you would introduce yourself and your client and then proceed.
Good morning. May it please the court, I'm Barney Brannon. I represent the appellant and defendant below, Peter Rysz, seated in the gallery. As the bailiff mentioned, I'm also joined by my associate, Joe Tremblay, who's a recent admittee to the New Hampshire bar and is in the process of getting himself admitted.
Well, we won't hold that against you.
Thank you, Your Honor. I just wanted to get that clear on this.
We clear the record on that. Yeah. Thank you, Mr. Brannon. Go ahead.
And with the court's indulgence, and I've spoken to the bailiff about it, I'd like to reserve 2 minutes.
That's up to you.
Yeah. Thank you, Your Honor. Members of the court, this case arises out of a divorce action from Windham County. We've raised 3 issues on appeal, 2 of which are legal issues, and we think significant legal issues that need addressing by this court because they raise issues that, while they've been swirling around for decades, in the case of the enforceability of a prenuptial agreement, and maybe less time since the property settlement statute was amended with respect to unvested interests. As a member of the practicing bar, I can tell you that the absence of direction from this court yields a significant amount of uncertainty for lawyers who are practicing in this area. So we humbly request that the court give serious consideration to these issues for the purpose of giving guidance to parties and counsel.
And Mr. Brannon, you said,
Yes.
vested interest only, is that?
That's correct, Your Honor. We understand that with respect to the property settlement statute, when the legislature amended the statute in 2013 to add Section 8 of 7, sorry, I should know this off the top of my head, Your Honor, but of Section 751 under the divorce statute, Title 15, what the legislature was essentially doing was codifying this court's decision with respect to the propriety of considering as a part of the marital estate parties' interests in future expectancies. And specifically what the court said was, with respect to, while the trial courts could consider an expectancy vested or unvested, with respect to third parties, they could be examined only with respect to the vested interests of the parties to the divorce, that is vested and basically non-alienable or non-amendable at that point. We understand that piece was clear.
Such as an irrevocable trust.
Correct, Your Honor. Yes. And so that piece was clear. What was left unclear was the scope of permitted examination and the tension between the limitations set forth in the statute and the broader principle articulated in Rule 26 of the Rules of Civil Procedure to permit parties broad discovery with respect to issues that are to come before the court.
Aren't we jumping over an issue here, Mr. Brannon? And
happy to take them in any order.
Well, my question may clarify this. You have this discovery issue that's
correct
hanging out here. But if you prevail on the prenuptial agreement, that issue goes away.
That's correct, Your Honor. We agree. In fact, the second
issue goes away.
Second and third issues both go away for all intents and purposes.
Well, so for all purposes.
Yeah. Indeed, Your Honor. No question. And if the court prefers, I'm happy to go back and address them in the order in which we addressed them in the brief.
That
So-
would be good.
Okay, so as you alluded to, Justice Eaton, the first issue has to do with the enforceability of the prenuptial agreement. These parties had a prenuptial agreement in place. And really what this case raises is the question of the definition of unconscionability in a prenuptial agreement and the points at which the trial court is to consider the question of unconscionability. And those are issues that have not really been addressed in any detail by this court in the 33 years since the court decided Bassler. And so perhaps in part because of that, the trial court in this case essentially applied Massachusetts law, which we respectfully believe was incorrect. Because
Are you zeroing in on the vitiating the status of marriage?
I am, yes.
There's no case in Vermont that's ever said that that's improper.
That's our argument. It's our argument that, well, there are two issues essentially. One is that we think that if you read the Massachusetts case law, and the Vermont case law, including Bassler, that it's clear that Vermont courts are more deferential to the rights of parties to arrange their legal relationships by a contractual arrangement, a prenuptial arrangement, and will enforce those subject to certain boundaries. And essentially,
Public charge.
correct. And one of the benefits of Judge Hayes' decision in the lower court here is she makes it quite clear that none of those other boundaries apply. There is no question but that the plaintiff, the appellee here, had the means to support herself. In fact, she was essentially making about what Mr. Rysz was making as of the time of the divorce. There was a disparity in their incomes at the time that they got married.
There's
There
a
was
finding to that
disparity
effect.
in their wealth. I'm sorry.
There's a finding to that effect.
That's correct. That's exactly right. And so with that in mind, really the question becomes, well, what is the standard that the court applied and in what circumstance? And so the court determined that the prenuptial agreement would not be unconscionable in the sense that the plaintiff would be left as a public charge, but rather that it was unconscionable at the moment that it was adopted, because the fact that there was such a disparity of wealth and at that moment a disparity of incomes between the parties that it vitiated the status of marriage. So in reading the Massachusetts decisions, what the courts there seemed to be saying and what Judge Hayes seemed to adopt was the idea that by the mere fact of changing their legal status from unmarried to married, there had to be some transfer of wealth from the wealthier party to the less wealthy party. And that's never been the standard articulated by this court. And candidly, our position is it should not be the standard articulated by this court.
And Mr. Brennan, there's no indication that the assets were not appropriately disclosed at the time of the prenuptial.
None, indeed. Judge Hayes specifically found to the contrary. That is, and the plaintiff didn't argue below that there was inadequate disclosure. There was full disclosure. Judge Hayes found that both parties fully disclosed their assets and that they had the benefit of legal counsel in so doing. So this isn't a case where you had pro se parties on either side. Both were represented by competent counsel. There was a full disclosure. And so they went in with full knowledge of the fact that there was, in fact, a disparity of assets and income between the parties at the time. And really the question,
Go ahead.
the question presented, I think, is under those circumstances, is it permissible within the scope of Vermont law that both parties, in this case, our client, the party with greater wealth, greater assets, and greater income, want to protect those and want to preserve the status of those assets and that income as of the time of their marriage? We cited a hypothetical example in our brief, Your Honor, and in reflecting upon it before coming up here, I think a better one would have been more appropriate. I don't think we need to consider other potential parties as we discussed in the brief. We can consider these parties. but with other circumstances surrounding the divorce. If these parties had signed this prenuptial agreement that's at issue in this case, and then decided a month, 2 months later, you know what, this was a mistake, we should get a divorce. Based upon the standard adopted by the trial court here, it would still be an unconscionable agreement. It would be an unconscionable agreement because according to the trial court's decision, at the moment that they got married, there had to be a promise of a transfer of wealth simply because of the fact that they had disparate wealth at the time that they got married.
Didn't the trial court here use the house provision as a way to tip this prenuptial agreement over?
That's correct, Your Honor. And it's a little, I mean, I think it's clear from the record, but you have to read a bit. But I think, and the court forthrightly acknowledged, she initially misread that particular provision.
And when she misread it, she said the prenuptial agreement was not unconscionable.
Right, even though she pronounced herself troubled.
Right, but then when she gets the right reading on it, then she strikes the.
Correct. So it couldn't be clearer what her view of the law is. And as we've argued, we think that's incorrect in light of Bassler, albeit without a great deal of guidance since Bassler. But we think that the standard articulated in Bassler, and that's always been affirmed by this court in other contexts, is we're going to allow parties to contract out of the legal regime within certain broad boundaries. And essentially what Judge Hayes was saying was, no, we're not going to do that. That the significant legal change in status in and of itself from unmarried to married should affect, particularly where there is a disparity of assets, should affect essentially a transfer of wealth.
So,
Mr. Brennan?
Mr. Brennan, oh, I'm sorry. Okay. Thank you. So, Mr. Brennan, are you, under Bassler, are you arguing that in order for the court to find unconscionability, the spouse who is challenging that antenuptial or prenup has to be close to being a public charge?
Well, I think Bassler articulated two alternatives, and you do hear a lot about the public charge language, and that's a pretty severe standard.
Mm-hmm.
But the court there also said that if the circumstances of the parties have changed significantly, I can cite an example because I had this case, but it got resolved before it made it to this court. But
That's good.
we always try, Your Honor. It's never, with all due respect to this court, it's never a good thing for our parties if we're standing here in front of you. If parties got married, signed a prenuptial agreement, very much like the one at issue here, no transfer, no change in assets. But over the course of the marriage, their standard of living changed dramatically. They had 3 children that at the time that they got married, they hadn't necessarily anticipated having. And the whole family had set a standard of living that was entirely dependent upon the wealth of one party. In that circumstance, under the language articulated in Bassler, the court could take into consideration the change in standard of living that had basically, in my particular case, it was a 15-year marriage at that point. So a much longer marriage. And as I say, with 3 children and a standard of living that changed dramatically. Under those circumstances, the court could say, you know what, it would be unconscionable to enforce the prenuptial agreement as it was drafted, as it was executed at the time of the marriage, in light of the changed standard of living, because it would leave the less wealthy spouse essentially unable to maintain the same standard of marriage, same standard of living, critically, at a time when there were minor children still in the household.
So, Mr. Brennan, is there an equitable determination when you're looking at unconscionability in a divorce case?
I think inevitably there is.
And that would be the situation where the standard of living has increased dramatically?
I think that's right. And also, it's a little unclear, as Justice Waples put it, how close to the charge of the state does one have to become before it becomes unconscionable? That's inevitably an equitable consideration as well, unless the court's able and prepared to define a bright line standard set by, I don't know what, the federal standard for poverty. So I think as with many things before the trial court, there are equitable considerations. But importantly, in this case, Your Honor, is that was not an issue. And the trial court's decision made it clear that was not an issue. There was not a question of whether or not the prenuptial agreement would be unconscionable if enforced at the time of the divorce. In Judge Hayes's mind, and we respectfully submit incorrectly, it was unconscionable at the moment that it was executed. It was unconscionable the instant that the parties became married. And we don't think that's the law in this state. I'm mindful that I may have exhausted all of my 2 minutes that I tried to reserve, but unless the court has any further questions, I have nothing to add.
Okay,
Thank you.
thank you very much. We'll hear from counsel for the appellee now, of course. Come on up.
Thank you.
Please introduce yourself and your client.
My name is Sharon Ants. My client is here in the gallery, Danielle Lacroix. And we agree this is a Wyndham case, a very long-standing Wyndham case, and here we are. So may it please the court, I fundamentally disagree with Attorney Brannon's analysis of this case. And that there are uncertainties about the body of law made by this court regarding prenuptial agreements. I think it's not disputed by any of us here that Bassler is the case that sets the standard. And neither do any of us, I think, disagree that the only part of that standard that's really in play today is the third standard, whether the substantive provisions of the agreement dividing the property upon divorce are fair to both. And I think that's in the standard of living that guts another party financially, or if it leaves them a public charge. So I think court, if it's challenged, and you only get to it if somebody challenges prenup, they do have to look at it a second time. And that's when they have to make that equitable, partially equitable determination, no matter what the parties agreed to, is it fair and equitable? And in this case.
Doesn't that go, excuse me, go ahead.
One thing that really perplexes me is Judge Hayes's statement that, well, this is essentially leaving the parties where they were before they were married. Well, isn't that the purpose of a prenuptial agreement in many cases? That seems to be the very purpose of one. And so if we agreed with you in this case, I worry that we're going to be voiding prenups if that's the test.
Right. And I don't think that that is the case. For sure, the very purpose of prenup is to protect separate assets. That's the main purpose that people enter into it. But at the end of the marriage, if it's being challenged, you're looking at the situation at that time as well. And in this case, for example, and I think you have to look at it on a case by case, this prenup provided that the parties could acquire joint marital property. And if they then got divorced, that would be separated 50-50. And nobody knew when they got married if that was going to happen, whether it's a 2-month marriage, 20-year marriage. At the time of divorce, there was no joint property. So when the court has to look at the time of divorce to see if someone's going to be a public charge or if the standard of living had significantly changed, that would have been a factor. If they had jointly held the marital home. There's a case law that says even if you got a worse deal because you signed the prenup, we're still going to uphold that unless it's unconscionable in the way that's been described here. And the way that's been described here, I think that best fits this case is the standard of living. There was no joint property acquired during the marriage to provide her with any marital assets. At the time of the divorce, she may have been earning a little more, but she had no property, none at all, whereas Mr. Rysz had the mortgage-free marital home and many other rental properties. They did have a child, and she's a primary custodian of the child, and prenups have been overturned on those grounds as well, where no thought had been made for having a child.
Ms. Annis, do you agree that the standard of living was similar throughout their relationship from the beginning when after they met, moved in together, and continued until the divorce was filed?
Yes.
So there wasn't a situation where there was a dramatic increase in assets or in a standard of living from going from one place to a very fancy place with cars and vacations and the like. That didn't really exist in this case?
No, but the standard of living was that they had a mortgage-free home in which to live in. And then at the time of divorce, she was unable to have that same standard of living because she had no home at the time of divorce. She would have to go out and she didn't have any assets to purchase a home, much less mortgage-free. So she didn't have that opportunity. And that's what made that look at the time of divorce say, well, that's far below the standard of living she enjoyed during their relationship, which was to be able to live in a mortgage-free home and have a home for her child.
But where is the line between protecting a standard of living and freedom of contract?
Well, that's where the discretion of the judge comes into play, applying the findings that they make to this individual case, and then assessing it on a case-by-case basis. Because of the having to assess it at the time it was executed and at the time it was time of divorce, you have to make findings and you have to, the trial judge has to exercise some discretion. So, what is the standard there? Abuse of discretion? Is this a abuse of discretion to say where one party is left with no assets whatsoever except a few stocks after an 8-year marriage, that complies with the law on prenups and allows for it to stand? If that was the case, frankly, why would there be any kind of analysis at the time of divorce? If it's true that you can only look at it at the time of execution, Are we gonna have a court that makes that pronouncement before people ever get married and sit down and say, here's a prenup, we're gonna pronounce right now whether it's conscionable or unconscionable?
Oh, but there is an initial level here, isn't there? I mean, she had an attorney.
Yeah.
He had an attorney. There was disclosure that he was worth a significant amount of money, and she signs the agreement. So where does the court step in to say, we're going to protect you from the consequences of the agreement that you freely made?
Under the Bassler standard, which clearly says that the court is obligated to review the substantial provisions of the agreement dividing the property upon divorce, make sure they're fair to each spouse. Bassler requires that to be done. And if that was the case, as you described, then there shouldn't be any judicial oversight of prenuptial agreements. They would just stand as is. You might as well take out the third provision. If the court finds that they were represented and they entered into the agreement voluntarily and freely and made a disclosure, well, that's that, you're stuck. But that's not what the law says. The law says it has to be evaluated both at the time that it was entered into and look at it at that time to see if the substantive provisions were fair. And necessarily any court is looking back when they do that. They're not doing it at that time. They're doing it when it's been challenged and you're in a divorce.
Right, and Judge Hayes, when she first looked back, said it was fair.
Right, because of the provision she thought that provided my client with a mortgage-free home, which kept her at the same standard of living that she enjoyed before and during the marriage, and that she did not have the assets to purchase her own. I don't necessarily disagree with vitiate the very status of marriage. I understand what Judge Hayes is saying. I think it's more of a equity argument on her part, but I think she has a point when she says, well, why bother get married at all? You know, marriage is a state recognized union that has protections and obligations. It is a policy of the state, a statutory policy, so that the state takes and the law takes many steps to enforce and interpret, and their whole goal is fair and equitable. Parties can contract those rights away, so it's not fair and equitable exactly as under Vermont law, but it is not unrestricted. And there is a obligation on the part of the court, and it's clear under Bassler that they have to have a piece of equity to that. And I agree with Justice Carroll. If you just looked at the time of execution, why are we even here? So I think you have to look at the equity of it and the two parts, both at the beginning and at the end. Thank you very much.
Okay, thank you. How much time does the appellant have, please?
Appellant has 12 seconds.
Well, there you go. 12 seconds.
I'll make a challenge, Your Honor. I really just have one point to make. I think that Attorney Yanis is trying to, after the fact, create a rationalization that would support the trial court's decision that the trial court itself did not rely on. She's arguing that there was a change in the standard of living, that Ms. Lacroix could not have maintained that standard of living. Judge Hayes made no such finding. In fact, on the contrary, what Judge Hayes specifically found was that Ms. Lacroix was, at the time that the prenup was under consideration, self-sustaining. She was capable of being self-sustaining based upon her own earnings at that time.
All right.
And ultimately, the findings of the court corroborate that. Thank you.
Thank you. Please call the conclusion of the hearing.
The next hearing